Okay, going live, reading evidence on page 17, character evidence, introduction. This is part 4. I'm only reading 6 parts. Character evidence refers to a person's general propensity or disposition, such as for honesty, fairness, peacefulness, violence, the evidence conveys a moral judgment in the sense that we usually think of a character trait as either bad or good. Evidence law is careful about admitting character evidence because we worry that a jury exposed to that evidence will decide the case, not on what they think happened, but on whether the parties are good or bad people. Purposes for offering character. The admissibility of character evidence usually depends on the purpose for which the evidence is offered. Character evidence might be offered as substantive evidence, meaning to prove a fact at issue in the case, or the following purposes: to prove a person's character in the rare situation where their character is directly an issue in the case, meaning an essential element of a claim or defense, or to serve as circumstantial evidence of how a person probably acted during the events of the case. This is also known as conduct in conformity with character or propensity evidence. This purpose for offering character evidence is the main focus of this module because it is permitted only in a few situations. Additionally, evidence of a witness's bad character for truthfulness might be offered for impeachment or rehabilitation purposes, that is, to attack or support the witness's credibility rather than to prove some fact in the case. For coverage, see the credibility and impeachment module. Methods of proving character. Depending on the purpose of the offer and the nature of the case, some or all of the methods of proving character may be allowed. Evidence of a person's specific acts, opinion testimony of a witness who knows the person, and testimony as to the person's general reputation in the community. Approach to character evidence. Consider the following questions. What type of evidence is being offered? Specific acts, opinion, or reputation? Is it a civil case or a criminal case? Does the evidence prove a pertinent character trait, meaning a trait that is important to the case? (4.2) Civil cases generally not admissible. In civil cases, character evidence is generally inadmissible to prove conduct in conformity, meaning it can be offered to prove how a person probably acted during the events of the current case. This is true regardless of which party seeks to offer the evidence. Note, as such, as discussed further in 4.6 infra, there is a limited exception to this rule that allows evidence of the defendant's prior similar acts in civil and criminal sexual assault and child molestation cases. There's two hypos. Part 4.2.1, inadmissible or admissible when character directly an issue. When proof of a person's character as a matter of substantial law is an essential element of a claim or defense, it is said that the character is directly an issue. This is rare, and for bar exam purposes is generally limited to defamation cases where the truth is a defense, plaintiff's character is at issue, negligent hiring and entrustment. Cases hired, entrusted person's characters at issue, and child custody cases, parents' characters at issue. When character is directly an issue, all forms of character evidence, reputation, opinion, and specific acts are admissible. Hypo C, skipping that, defendant's character in criminal cases, section 4.3. As a general rule, The prosecution cannot initiate evidence of a defendant's bad act. Bad character to show conduct and conformity. In other words, they cannot introduce such evidence during their case in chief to show that it is within the defendant's character to commit the charged crime. However, because the defendant's life or liberty is at stake, the defendant is permitted to open the door to introduce evidence of their own good character to show their innocence. How defendant proves character. Under the federal rules, the defendant may offer evidence of their good character to prove their conduct in the case. The evidence must concern a pertinent trait, and such evidence must be the form of reputation and/or opinion testimony. In other words, a character witness may offer testimony as to the defendant's good reputation for a pertinent trait and may give their personal opinion concerning that trait of the defendant. Evidence of specific acts of good conduct by the defendant is not admissible to prove character for purposes of showing conduct in the case. Remember that a defendant does not open the door to character evidence merely by taking the stand and testifying. Taking the stand places the defendant's credibility as opposed to character in issue, meaning the prosecution is limited to offering impeachment evidence rather than substantive character evidence. How prosecution reviews defendant's character evidence. Once the defendant opens the door by introducing character evidence, the prosecution may review it by either or both of the following methods. Offering evidence of defendant's bad character, the prosecution can call its own character witnesses to provide reputation or opinion testimony about the defendant's bad character for the trait in question. Cross-examining the defendant character witnesses. Prosecution can cross-examine the defendant's character witnesses regarding their basis for the testimony by asking, have you heard or did you know questions about specific acts of the defendant that show the defendant's bad character for the trait in question. The questioning is admissible only to impeach the witness by showing their lack of knowledge. It is not admissible to prove the defendant's character. Remember that when the prosecutor reviews by this method, they are limited to questioning the defendant's character witness on cross-examination. They cannot introduce by extrinsic evidence of the misconduct. Why? Because the permitted purpose of a cross-examination is to show the character witness's lack of knowledge, not to prove the defendant's bad character. There's another orange box. The other exam tip is any misconduct, including prior arrests, may be inquired about while cross-examining a defendant's character witness. Be careful to distinguish asking a character witness whether they are aware of the defendant's prior arrest, which is proper, and impeaching a witness with the witness's own arrest, which is improper. Victim's character in criminal case. When defendant can initiate, except in sexual assault cases, the defendant may introduce reputation and/or opinion evidence of a bad character trait of the alleged crime victim when it is relevant to show the defendant's innocence. Although a victim's character usually has no bearing on the defendant's innocence, it becomes relevant when the defendant claims self-defense and argues that the victim was the first aggressor. Prosecution rebuttal. Once the defendant has introduced evidence of the victim's bad character for a pertinent trait, usually violence, the prosecution may rebut the reputation or opinion evidence of the victim's good character for the same trait, or defendant's bad character for the same trait. Now here's an exam tip. The rules above apply where evidence of the victim's character is being offered for propensity purposes to prove how the victim likely acted during the altercation at issue, but evidence of a victim's character might also be offered for a non-propensity purpose to prove the defendant's state of mind at the time of the altercation. If the defendant knew at the time of the altercation that the victim had a violent reputation or had committed violent acts in the past, evidence of the victim's reputation or acts may be admitted to prove the defendant acted reasonably in responding to the victim's aggression. The above prohibition on specific acts does not apply when the evidence is offered for a non-propensity purpose. When prosecution can initiate rebuting self-defense claim in homicide cases, there is a special rule that allows the prosecution to offer evidence of a victim's good character for peacefulness in a homicide case in which the defendant pleads self-defense. Evidence of any kind, not just character evidence, that the victim was the first aggressor, for example, eyewitness testimony that the victim struck first, opens the door to evidence that the victim had a good character for peacefulness. The prosecution can introduce this evidence regardless of whether the defendant has introduced character witness of the victim's generally violent propensity. There is a section for rape victims, past behavior generally inadmissible in a civil or criminal proceeding involving alleged sexual misconduct. Evidence offered to prove the sexual behavior or sexual disposition of the victim is generally inadmissible. Exceptions in criminal cases. In a criminal case involving alleged sexual misconduct, specific instances of a victim's sexual behavior are admissible to prove that someone other than the defendant is the source of semen injury or other physical evidence, although specific instances of sexual behavior between the victim and the defendant are admissible by the prosecution for any reason and by the defense to prove consent. Exceptions in civil cases. In a civil case involving alleged sexual misconduct, evidence of the alleged victim's sexual behavior is admissible if it is not excluded by any other rule and its probative value substantially outweighs the danger of harm to the victim and of unfair prejudice to any party. Notice that this is not the same balancing test as the Rule 403 and favors excluding the evidence. Evidence of an alleged victim's reputation is admissible only if it has been placed in controversy by the victim. Section 4.5, other misconduct for non-character purpose. As we've already learned, evidence of a person's other crimes, wrongs, or acts is generally admissible if offered solely to prove character for purposes of inferring conduct in conformity. In other words, the evidence, he's been not moving a whole lot. Where he's sore. Evidence can't be offered just to suggest that because the defendant tends to do bad things, they are more likely to have committed the charged crime. Example, D is charged with robbing Bank A. The fact that D robbed Bank B 6 months later would be inadmissible character evidence. 4.5.2, admissible if independently relevant. Evidence of a person's other crimes, wrongs, or acts is admissible if relevant to some issue other than the character or propensity to commit the crime charged or the alleged act in civil cases. In other words, if a defendant's other misconduct shows something specific about the charged crime, something more than just bad character, evidence of that misconduct may be admissible to prove that non-character fact. Such evidence is usually offered in criminal cases, but it can also be used in civil cases, such as in tort actions for fraud and assault. Non-character purposes for offering the evidence may include motive intent to show guilty knowledge or lack of good faith, absence of mistake, or accident, identity, for example, signature crimes such as modus operandi or common plan scheme. Usually committing one crime to prepare for another. The mnemonic device mimic is a convenient way to remember the most common non-propensity purposes for offering evidence in a defendant's other crimes or misconduct. Again, it's motive, intent, mistake, identity, common plan, or scheme. Even though mimic evidence is a helpful shorthand, keep in mind it is not a comprehensive list of permitted purposes. The evidence can be omitted as long as it is relevant to any purpose other than the defendant's general character or propensity to commit the charged crime. Examples of independent relevant misconduct motive. Intent. And it's giving hypotheticals for each. Requirements for admissibility. The misconduct may be proved by any evidence such as witness testimony, the defendant's criminal conviction, etc. There must be evidence sufficient to support a jury finding that the defendant committed the other misconduct, meaning a reasonable juror could come to this conclusion. Additionally, evidence of the misconduct is subject to the usual 403 standard. Probative value must not be substantially outweighed by danger of unfair prejudice. Notice requirement in criminal cases. In a criminal case, the prosecutor must provide reasonable notice of any evidence of this type that the prosecutor intends to offer at trial. Such notice usually must be in writing and provided in advance of the trial, but the court may use lack of pretrial notice for good cause. The notice must articulate the non-propensity purpose for which the evidence will be offered and the reasoning that supports the purpose. Defendants' similar misconduct in sex crime cases. You have learned in this module that the use of propensity evidence is subject to many restrictions and that evidence of specific acts of misconduct is generally never admissible to show propensity. However, as we pointed out earlier, there is an important exception to this rule. Evidence of the defendant's other acts of sexual assault or child molestation. The party intending to offer this evidence must disclose it to the defendant 15 days before the trial or later with good cause. Such evidence, this is a tip, exam tip, such evidence is relevant for any purpose, including the defendant's propensity to commit sex crimes. This is one situation where evidence of the defendant's specific acts is admissible to show their propensity to commit the act at issue in the case. Testimonial evidence, competency of witnesses. Witnesses must pass tests of basic reliability to establish their competency to give testimony, but they are generally presumed to be competent until the contrary is established. Federal rules of competency. The rules do not specify any mental or moral qualifications for witness testimony beyond these two limitations. There must be evidence sufficient to support a finding that the witness has personal knowledge of the matter about which they are to testify. Note that proof of personal knowledge may consist of the witness's own testimony, and the witness must give an oath or affirmation to testify truthfully. If a witness requires an interpreter, the interpreter must be qualified to take an oath to make a true translation. Distinguishing personal knowledge and hearsay objections. Sometimes it may be difficult Determine whether the proper objection testimony is 1, lack of personal knowledge, or 2, hearsay. The question is, does the fact testified to match the fact that was perceived by the witness? If not, personal knowledge is the proper objection. Modern modifications of the common law disqualifications. The federal rule have removed the common law witness disqualifications for lack of religious belief, conviction of a crime, and interest in the lawsuit. In other words, these issues do not affect competency. Interest in the lawsuit would be bias, which would affect their credibility, potentially impeaching them, but it wouldn't disqualify them and amount to a ruling of incompetence. C, to provide testimony. Other common law disqualifications are modified as follows. Children, case-by-case determination, insanity, judge and jurors. For children, the competency of a child depends on the capacity and intelligence of the particular child as determined by the trial judge. For insanity, an insane person may testify provided they understand the obligation to speak truthfully and have the capacity to testify accurately. The presiding judge may not testify as a witness. Likewise, jurors are incompetent to testify before the jury in which they are sitting. Jurors' inquiry into verdict or indictment. During an inquiry into the validity of a verdict or indictment, a juror is generally prohibited from testifying about what occurred during deliberations or about anything that may have affected the juror's vote. The court may not receive evidence of a juror's statement on such matters. However, a jury may testify as to whether any extraneous prejudicial information was improperly brought to the jury's attention, whether any outside influence was improperly brought to bear on any juror, whether there is a mistake on the verdict form, or whether any juror made a clear statement that they relied on racial stereotypes or animus to convict a criminal defendant. The rationale for allowing this evidence is to permit the court to determine whether the defendant's Sixth Amendment right to a jury trial was violated. Not every comment indicating racial bias will qualify. The court must find that racial animus was a significant motivating factor in the juror's vote to convict. Dead Man Acts 5.1.3. Ordinarily, a witness is not disqualified merely because they have an interest in the outcome of the litigation. However, some states have what are known as Dead Man Acts. These statutes provide that a civil case, an interested person or their predecessor in interest is incompetent to testify to a personal transaction or communication with the deceased when such testimony is offered against the representative or successors in interest of the deceased. A person is interested if they stand to gain or lose by the judgment, or if the judgment may be used for or against them in a subsequent action. No, there is no Dead Man's Act in the federal rules, but a state act will apply in federal cases when state law under the Erie Doctrine provides a rule of decision, most diversity cases, in parentheses it says. Thus, you should apply the Dead Man Act rules on the multi-state examination only if the question explicitly states that the particular jurisdiction in which the case arises has a Dead Man Act. Yeah, because that's going to happen. Form of questioning. The federal rules state that the judge should exercise reasonable control over the examination of witnesses in order to aid the ascertainment of truth, to avoid wasting time, and to protect witnesses from harassment. The following rules apply, but keep in mind that the judge ultimately has discretion to control the questioning. 5.2.1 leading questions. Questions that suggest the desired answer are generally allowed only on cross-examination and are not permitted on direct examination. However, the court will ordinarily allow leading questions on direct examination in the following circumstances: to elicit preliminary or introductory matter, when the witness needs help responding because of loss of memory, immaturity, or physical and mental weakness, or when the witness is hostile, an adverse party, or a witness affiliated with an adverse party. Scope of cross-examination. A party has a right to cross-examine any opposing witness, but the scope of cross-examination is frequently a matter of judicial discretion. Cross-examination is generally limited to the scope of direct examination, including all reasonable inferences that may be drawn from it, and matters that test the credibility of the witness. The permitted methods of impeachment are covered in the credibility and impeachment module. 5.2.3 Other improper questions and answers. Questions that are misleading cannot be answered without making an unintended admission. Compound, requiring a single answer to more than one question. Argumentative, conclusory, accumulative, unduly harassing, embarrassing. Call for a narrative answer, speculation, or assume facts not in the evidence are improper and are not permitted. Answers that lack foundation, the witness has insufficient personal knowledge, and answers that are non-responsive do not answer the specific question asked may be stricken. Page 34. I have like 10 more pages to go, but I just went through like 15 in a pretty short period, like 26 minutes. Using documents to aid oral testimony, section 5.3. As a general rule, a witness cannot read their testimony from a prepared memorandum. They must testify on the basis of their current recollection. However, a memorandum or other record may be used in certain circumstances. You should watch for hearsay issues whenever a witness uses a document on the stand. Anytime you encounter an exam question in which a business consults a writing, keep in mind the differences between refreshing recollection and recorded recollection, which are covered below. The fact patterns are very similar and could be confusing if you have not thoroughly memorized the distinguishing features. That was the exam tip. 5.1 Refreshing recollection, present recollection revived. A witness may use any writing or object for the purpose of refreshing their present recollection. They usually may not read from the writing while testifying because the writing is not authenticated and not in evidence, and thus there is no hearsay concern. Safeguards against abuse. Adverse parties options. Whenever a witness has used a writing to refresh their memory while on the stand, the adverse party is entitled to have the writing produced at trial, cross-examine the witness about the writing, and introduce portions of the writing related to the witness's testimony into evidence. If the witness refreshed their memory before taking the stand, an adverse party is entitled to the above options only if the court decides that justice requires it. The last section title was 5.3.1 Refreshing Recollection, Present Recollection Revived. So they don't read from it, but they can refer to it and then give testimony. But the opposing party can enter into evidence. Failure to produce or deliver writing in a criminal case. If the prosecution fails to produce or deliver a writing as ordered, the judge may strike the witness's testimony and, if justice requires, declare a mistrial. When the defense fails to comply, or in a civil case, the judge has more discretion and can issue any appropriate order. Now, the next section, 5.3.2, past recollection, recorded recollection, where a witness states that they have insufficient recollection of an event to enable them to testify fully and accurately, even after they have consulted a memorandum or other record given to them on the stand. The record itself may be read into evidence if a proper foundation is laid. While the record is now hearsay, because it is being offered into evidence, it is admissible under a recognized exception to the hearsay rule. The foundation must include proof that the witness has insufficient recollection to testify fully and accurately, that is, showing the documentation to the witness fails to jog their memory. The witness had personal knowledge of the facts in the record when the record was made. The record was made by a witness or under the direction, or it was adopted by the witness. Adoption means that another person made the record and the witness said or did something to indicate that they agreed with the record's contents, and the record was made or adopted when the matter was fresh in the witness's mind and the record accurately reflects the witness's knowledge. In other words, even though the witness cannot currently remember the facts, this requirement is satisfied where the witness vouches for the accuracy of the record at the time that it was made or adopted. So I'm going to take a picture of this because it's so many elements. I always forget them.
I'm not bugging you. Please send for it. Let's see if I read it wrong. I did. She's trying to charge me for late rent, and I'm like, I'm not late. I'm not late until the end of this month.
I literally haven't paid mine yet either, just because I'm lazy.
And she's got a weird name on her. Like, she's not listed as her actual name on Venmo. I wish I was paying you right now. I just feel bad for sitting here in the house.
You can pay mine while you're at it, because I just need to do it.
I could, and I find her on the street.
Although the record may be read into evidence and heard by the jury, it cannot be admitted into evidence as an exhibit unless offered by an adverse party. Straighten out. The rationale is that we don't want the jury giving the record undue weight when it should serve as a substitute for a witness's testimony and nothing more. While while this may seem like a minor point, it tends to come up on the bar exam. Present recollection refreshed versus recorded recollection. Oops. Present recollection refreshed. Any writing may be used to refresh a witness's memory. Things other than a writing may also be used. For example, a photograph. The witness cannot read from the writing. While testifying, there is no hearsay problem because if writing is not offered into evidence. Only a record that meets several foundational requirements, for example, timely made by the witness. Witness cannot read from the writing while testifying, and there is no hearsay problem because the writing is not offered into evidence. Recorded recollection, only a record that meets several foundational requirements. Example, timely made by witness. Witness cannot remember the events after reading record may be used. The record itself is read into evidence, but it is received as an exhibit unless offered by an adverse party. The record itself is read into evidence. And this is hearsay, but it falls within a specific exception to the hearsay rule. All right. Opinion testimony, section 5.4. The general policy is of the law is to prohibit admissibility of opinion evidence except in cases where the courts are sure that it will be necessary or at least helpful. Opinion testimony by lay witness. Requirements, opinions by lay witness. Lay non-expert witness are generally inadmissible. However, there are many cases where no better evidence can be obtained. Opinion testimony by a lay witness is admissible when it is rationally based on the witness's perception, helpful to a clear understanding of the witness's testimony, or helpful to the determination of a fact and issue, and not based on scientific, technical, or other specialized knowledge. Situations where opinions of lay witnesses are admissible. An opinion of a lay witness is generally admissible with respect to the general appearance or condition of a person, the state of emotion of a person, matters involving sense recognition, voice or handwriting identification, the speed of a moving object, the value of the witness's own services or property, the rational or irrational nature of another's conduct, and a person's intoxication. Situations where opinions of lay witnesses are not admissible. A lay witness cannot give an opinion as to whether they or someone else act as an agent or whether a contract was made, as these are legal conclusions that require specialized knowledge. The lay witness may testify only as to surrounding facts. Cannot give an opinion as to whether they or someone else act as an agent or whether a contract was made, because they're legal conclusions. But only may testify to surrounding facts. Admissible opinions of lay witnesses. And it lists a general appearance or condition of a person. Example, she seemed ill. He was about 80 years old. State of emotion, she was angry or he was distraught. Matters involving sense recognition, the suitcase was heavy. He smelled of garlic. Voice or handwriting identification, it sounded like Mark. That's Fran's handwriting. Speed of moving object, the truck was going very fast, or if experienced in estimating rates of speed, the truck was going at least 60 miles per hour. Value of own services, my time is worth $50 per hour. Rational or irrational nature of another's conduct, he was acting crazy. Intoxication, it says here foundation may be required. She was slurring her words and smelled of gin. She was drunk. Opinion testimony by expert witnesses. Requirements for admissibility. The federal rules provide that for expert testimony to be admissible, the witness must be qualified as an expert. 1. 2. The witness must be at least reasonably certain about their opinion. And 3, there's a lot here. 3, the subject matter must be one where scientific, technical, or other specialized knowledge will be helpful to the jury. 4, the opinion must be based on sufficient facts or data. 5, the opinion must be the product of reliable principles or methods. And 6, the expert must have reliably applied the principles and the methods to the facts of the case. So I'm going to open the other PDF. Or just go to page 38 somewhere. That's interesting. Okay, I'm a bit further along than that one. Okay, I'm on page 39. Okay, so I'm moving to page 40. Qualification as an expert. The witness must be qualified as an expert. This requirement is satisfied if they possess special knowledge, skill, experience, training, or education. Reasonable probability. The expert must have a reasonable level of certainty in the correctness of an opinion. A mere guess or speculation is not sufficient. The subject matter must be one where specialized knowledge would be helpful to the jury. Proper factual basis. The expert's opinion must be supported by a proper fact. The opinion can be based on any of the following 3 possible sources of information. 1, facts based on the expert's own personal observation. For example, the expert personally examined the injured plaintiff. Facts made known to the expert at trial. For example, the expert reviews testimony from the trial or counsel, relates that facts to the expert on direct examination in the form of a hypothetical question. And 3rd, facts not known personally but supplied to the expert outside the courtroom and of a type reasonably relied upon by other experts in the particular field. Such facts need not be admissible as evidence, but the facts would be inadmissible. But if the facts would be inadmissible, the proponent of the expert testimony must not disclose the facts to the jury unless the court determines that their probative value in helping the jury evaluate the expert's opinion substantially outweighs their prejudicial effect. Note that this is a reverse Rule 403 balancing test that favors non-disclosure. Unless the court orders otherwise, the expert need not disclose the basis of the opinion on direct examination. However, the expert may be required to disclose such information on cross-examination. All right, now, page 42, 43, 44, 45 actually gets me to section 6. And I'm going to read that until I get to section 7. And section 7 is on hearsay, but section 6 is about impeachment, and it goes on to page 58. Not what I was expecting to do, but let's go through it. I'm just going to expand, though, because it's like too small to say. Reliability. Judge as gatekeeper. Federal courts determine the reliability of all expert testimony, scientific or otherwise, and have discretion to consider a wide variety of factors. The traditional Dauber factors for reliability of scientific testimony include 1. Whether the expert's theory or methodology has been tested. 2. Whether it has been subject to peer review and publication. 3. Its known or potential error rate. 4. The existence and maintenance of standards controlling its operation. And 5. Whether it is generally accepted in the relevant field. Various other factors may be appropriate depending on the circumstances and subject of expert testimony. So, has the methodology the expert's using been tested, peer-reviewed, publicized? What's the error rate or potential error rate? And what standards apply? And lastly, is it generally accepted in the relevant field, which is actually should be first. Those are considerations of, those are the Dauber factors? Got it. Use of learned treatise during examination. A relevant excerpt from a treatise, periodical, or pamphlet may be used during expert testimony. Under the federal rules, these learned treatises can be used not only to impeach experts, but also as substantive evidence, that is, to prove what the treatise says is true under the learned treatise exception to the hearsay rule, subject to the following limitations. The treatise must be established as reliable authority by 1, the testimony of the expert on the stand, 2, the testimony of another expert, or 3, judicial notice. The excerpt must be used in the context of expert testimony, meaning it is called to the attention of an expert witness on cross-examination or relied upon by an expert witness during direct examination. The excerpt is read into evidence but cannot be received as an exhibit. See opinion on ultimate issues. An expert is generally permitted to render an opinion as to the ultimate issue in the case. For example, X was drunk, or X was insane, or that X's signature was on the document. However, in a criminal case in which the defendant's mental state constitutes an element of the crime or defense, an expert may not state an opinion as to whether the accused did or did not have a mental state issue. Court-appointed experts. A court has broad discretion to appoint expert witnesses, although this rule does not limit any party's right to call its own experts. On a party's motion or its own, the court may order the parties to show cause why experts should not be appointed and may ask the parties to submit nominations. The court may then appoint any expert who consents to act, and the court must inform the expert of their duties. The expert must advise the parties of any findings they make, and the party may depose the expert, call the expert as a witness, or cross-examine the expert. The expert is entitled to reasonable compensation as set by the court. The court may authorize disclosure to the jury that the expert was appointed by the court. Exclusion and sequestration of witnesses. Upon a party's request, the trial must order witnesses excluded from the courtroom. The trial judge must order witnesses excluded from the courtroom upon the party's request. The judge may also do this on their own motion. The judge, however, must not exclude 1, a party or a designated officer or employee of the party, 2, a person whose presence is essential to the presentation of the party's claim or defense, or 3, a person statutorily authorized to be present. 5.6, statutes called or examined by court. The court may examine a party's witness or call its own witnesses. Each party is entitled to cross-examine a witness called by the court. A party may object to the court's examining or calling a witness either at that time or at the next available opportunity when the jury is not present. So we're now at part 6, credibility and impeachment. General concepts. Impeachment refers to discrediting a witness. When evidence is admissible only to impeach, it is not being offered as substantive evidence, that is, to prove some fact at issue in the case, but to show that the witness can't be trusted. 6.1.1, accrediting or bolstering statute generally prohibited. Generally, a party is not permitted to bolster or credit the testimony of their witness, for example, by introducing a prior statement by the witness that is consistent with their testimony until the witness has been impeached. Part A, exceptions to the rule against bolstering. In certain cases, a party may offer evidence that the witness made a timely complaint in a sexual assault case, for example, or a prior statement of identification, usually identifying the defendant as the perpetrator of the charged crime, even if this tends to bolster their in-court testimony. The prior identification may also serve as substantive evidence that the identification was correct. See the hearsay module. Any party may impeach. Under the federal rules, a witness may be impeached by any party, including the party who called them. Tip: when a question involves a party impeaching their own witness, be sure to avoid the following wrong answer choice reflecting the traditional rule, which prohibited impeaching your own witness unless the witness is an adverse party or identified with an adverse party, is hostile and affirmatively uncooperative, is one whom the party is required by law to call, or gives surprise testimony that is affirmatively harmful to the party calling them. So that used to be the case? Like, I feel like I'm more confused now that I read the test tip. Those are all wrong choices. Impeachment method. Impeachment evidence can come from only 2 possible sources. Cross-examination, eliciting facts from witnesses that discredit their own testimony, or 2, extrinsic evidence, calling other witnesses or introducing documents that prove the impeaching facts. Certain grounds for impeachment require that a foundation be laid during cross-examination before extrinsic evidence can be introduced. Other grounds allow impeachment to be accomplished only by cross-examination and not by extrinsic evidence. Note the term cross-examination is used for convenience because it is usually an adverse witness who is impeached. But remember that the party may impeach their own witness, which would be on direct or redirect examination. Okay, so I'm going to read the first sentence again because this comes up actually a lot. Impeachment evidence can come from only 2 possible sources: cross-examination and extrinsic evidence. Certain grounds for impeachment require a foundation to be laid during cross-examination before extrinsic evidence can be introduced. Other grounds allow impeachment to be accomplished only by cross-examination and not by extrinsic evidence. So it's not telling me which is which right now, but I have a hint because some kind lecturer said right here that when it's a present inconsistent statement, that extrinsic evidence may be entered to even if denied. I think, and then, yeah, if denied, that is whatever whatever they were asked on cross-examination. Did you steal your boss's watch yesterday? If you say no, and then extrinsic evidence is proper foundation probably is required to enter extrinsic evidence. That's okay. I'm sorry, not for prior inconsistent statement, but for bias and motive. And on the other hand, no extrinsic evidence, it may be entered for specific acts of misconduct which bear on veracity. And last, extrinsic evidence may be entered when it relates to reputation and opinion of the witness's veracity. Okay, and thus, this means for impeachment question, you should always ask yourself, is the source of the impeachment evidence cross-examination of the witness being impeached, or is it extrinsic evidence? If it is extrinsic evidence, can it be admitted under the impeachment method being used? And third, what, if any, foundation requirements are there for impeachment methods being used? In the discussion that follows, impeachment methods 1 through 4, prior inconsistent statements, bias, sensory deficiencies, contradiction involve impeaching witness with facts that are specific to the current case. I don't have sensory deficiencies here. And impeachment methods 5 through 7, opinion or reputation evidence or truthfulness. What just happened? Truthfulness. Untruthfulness, prior convictions and bad acts involve impeaching a witness with their general bad character for truthfulness. Prior inconsistent statements. Number 1, in section 6.2.1, a party may show by cross-examination or extrinsic evidence that a witness has, on another occasion, made statements inconsistent with their present testimony. To prove the statement by extrinsic evidence, a proper foundation must be laid and the statement must be relevant to some issue in the case. Okay, so I guess I'm going to add this to my list. Because it's saying extrinsic evidence can be entered for prior inconsistent statements if it's relevant and in proper foundation. I think that's what I just read. What else? Most inconsistent statements are clearly contradictory. For example, a witness testifies that the light was red, but previously told someone that the light was green. A prior statement that omits the fact asserted during the current testimony may constitute a inconsistency if it would have been natural for the witness to include the fact in the statement if they believed it to be true. On its own, a witness's present lack of memory of a fact is generally not inconsistent with a prior statement relating that fact. However, the court may find an inconsistency where the witness's memory loss appears to be feigned. When admissible as substantive evidence, usually prior inconsistent statements are hearsay, admissible only for impeachment purposes. If, however, testifying witness is prior inconsistent statement was made under oath about a prior proceeding, it is admissible non-hearsay and may be admitted as substantive evidence of the facts stated. See the hearsay module. The rationale is that the statement is reliable because of the oath and because the witness is now subject to cross-examination about the statement. Foundation for extrinsic evidence. Extrinsic evidence can be introduced to prove a prior inconsistent statement only if its content is not collateral, meaning it is probative of some fact of consequence in the case or says something about the witness's credibility beyond just showing the witness made an inconsistent statement, and at some point the witness is given an opportunity to explain or deny the statement, and the adverse party is given an opportunity to examine the witness about the statement. Exam tip. Remember that under the federal rules, the opportunity to explain and deny can be given before or after introduction to extrinsic evidence is introduced, but the MBE tests the federal rules. That means. And go back. Exceptions to foundation requirements. The foundation requirement above, giving the witness an opportunity to explain or deny, allowing the adverse party to examine them, does not apply in the following circumstances. The foundation requirement does not apply if the prior inconsistent statement is an opposing party statement. See the hearsay module. As discussed in 6.4 below, an inconsistent statement made by a hearsay declarant can be used to impeach the hearsay declarant despite the fact of a foundation. The court may dispense with the foundation requirement where justice requires, for example, when the witness has left the stand and is unavailable when their inconsistent statement is discovered. Bias or interest. Evidence that the witness is biased or has an interest in the outcome of the case tends to show that the witness has a motive to lie. Examples: a witness is a friend, relative, or employee of the party. An expert witness is being paid by the party, like a lot, and a witness has a grudge against the party. Like every expert's being paid by the party that called them. Just show for free. Foundation of extrinsic evidence. Because impeachment with bias is not specifically addressed by the federal rules, much is left to the court's discretion. The majority rule is that before a witness can be impeached by extrinsic evidence of bias or interest, they must first be asked about the facts that show bias or interest on cross-examination. Note that the court has discretion to permit extrinsic evidence even if the witness admits the bias. Sensory deficiencies. 6.2.3. A witness may be impeached by showing either on cross-examination or by extrinsic evidence that the faculties of perception or recollection are so impaired as to make it doubtful that they could have perceived those facts. A witness may also be impeached by showing that they had no knowledge of the facts to which they testified. There is no foundation requirement for proving the sensory deficiency with extrinsic evidence, meaning the witness does not need to be confronted with the impeaching fact. Bad eyesight, hearing, poor memory, consumption of alcohol or drugs at the time of the event or while on the witness stand are examples. Contradictory facts. Although not specifically addressed in the federal rules, impeachment by contradiction is a recognized method of impeachment. The cross-examiner, while questioning the witness, can try to make the witness admit that they lied or were mistaken about some fact that they testified to during direct. If the witness admits a mistake or lie, they have been impeached by contradiction. However, if the witness sticks to their story, the issue becomes whether extrinsic evidence contradiction. And then the other one was sensory deficiency. I just totally wrote it in the wrong place. So there's a couple more things here than we originally wrote down. What was I saying? Contradiction. Got it. However, if they stick to their story, the issue becomes whether extrinsic evidence may be used to prove the contradictory fact. The answer is yes, extrinsic evidence is permitted unless the contradictory fact is collateral, meaning it has no significant relevance to the case of the witness's credibility. Opinion or reputational evidence for truthfulness. A witness may be impeached with reputation or opinion evidence of their own bad character for truthfulness to suggest that they were not telling the truth while on the stand. This is accomplished by calling a character witness to testify about the target witness's bad reputation and the character witness's low opinion of the target witness. Conviction of a crime, 6.2.6. A witness may be impeached by proof of a conviction. An arrest or indictment is not sufficient for certain crimes. A pending review or appeal does not affect the use of a conviction for impeachment. Note that this is a form of character evidence in that it suggests the witness is a criminal type and thus must be willing to lie. As noted in the character evidence module, the rules regulating character evidence vary depending on the purpose for which the character evidence is offered. If offered to impeach a witness by showing the witness was convicted of a crime, the applicable rules are in this section, not in the character evidence module. A, type of crime. Any crime involving dishonesty or false statement. A witness may be impeached by any crime, felony, or misdemeanor requiring an act of dishonesty or false statement. The court has no discretion to bar impeachment by these crimes, provided that the conviction isn't too old, which we discussed below. Here's a test tip. Although many crimes are arguably dishonest in nature, courts interpret this category narrowly to include only crimes in the nature of crimes falsi. For example, perjury, false statement, criminal fraud, embezzlement, false pretense. Simple theft, for example, is not considered a crime of dishonesty or false statement. Look for a crime that involves some uttering of false words. I think in California it's moral turpitude, crimes of moral turpitude. Felonies. Felony not involving dishonesty or false statement. A witness may also be impeached by a felony that does not involve dishonesty or false statement. For example, murder, robbery, rape. But the court has discretion to exclude these convictions. The balancing test depends on whether the witness is the defendant in a criminal case or someone else. If the witness being impeached is a criminal defendant, the court will exclude the conviction in the prosecution if the prosecution has not shown that its probative value outweighs the prejudicial effect. This is a more difficult balancing test than for other witnesses. In the case of all other witnesses, the court will exclude the conviction if it determines that its probative value is substantially outweighed by the prejudicial effect. This is the standard Rule 403 balancing test, which favors admitting the evidence. Good thing we're skipping these hypos. Oops. Too far. Okay, only like 3 more pages. Impeachment on collateral matter. Okay, but first is a test tip. Remember that asking about bad acts does not include inquiring about arrests. An arrest itself is not a bad act. Thus, it is permissible to ask a witness whether they embezzled money from their employer. It is not permissible to ask them whether they were arrested for embezzlement. Impeachment on collateral matter. But why not? Is that just because it's a different term? Impeachment on a collateral matter. Where a witness makes a statement not directly relevant to the issue in the case, the rule against impeachment on a collateral matter prohibits a party from proving the statement untrue either by extrinsic evidence or by a prior inconsistent statement. Impeachment of hearsay declarant. The credibility of a hearsay declarant may be attacked, and if attacked, may be supported by evidence that it would be admissible if the declarant had testified as a witness. In other words, because the hearsay declarant functions as a sort of witness, the jury has heard their statement, even if they aren't present at trial. The hearsay declarant can be impeached by any of the impeachment methods that we have discussed. But the difference is that the hearsay declarant need not be given the opportunity to explain or deny a prior inconsistent statement. In addition, the party against whom the out-of-court statement was offered may call the hearsay declarant as the witness and cross-examine them about the statement. For purposes of this rule, a hearsay declarant means a person whose out-of-court statement has been admitted into evidence, 1, under the exception of the hearsay rule, or 2, as a vicarious statement of an opposing party. Rehabilitation. A witness who has been impeached may be rehabilitated by the following methods. Explanation and redirect. The witness on redirect may explain or clarify facts brought out in cross-examination. 2, good character for truthfulness. when the witness's general bad character for truthfulness was attacked by reputation or opinion testimony, prior convictions, or other prior acts of misconduct, the witness may be called to give reputation or opinion testimony about the impeached witness's good character for truthfulness. Note that the character witness cannot testify about specific acts of truthful conduct by the impeached witness. Only reputation and opinion are allowed. Remember that rehabilitation must meet the attack. For example, if a witness was impeached with a bad eyesight, it would make sense to rehabilitate them with the evidence of their good character for truthfulness. It would not make sense thus. This method of rehabilitation is available only where the witness's general bad character for truthfulness has been attacked. So you have to, quote, meet the attack. Prior consistent statements. There are two situations in which the party can rehabilitate a witness for introducing the witness's prior consistent statement. First, if the testimony of the witness has been attacked by an express or implied charge that the witness is lying or exaggerating because of some motive, previous consistent statement being made by the witness before the onset of the alleged motive is admissible to refute the evidence. Second, if the witness's testimony is impeached on some different ground other than a general attack on the witness's character for truthfulness, such as an inconsistency or charge of faulty memory, counsel may introduce a prior consistent statement made by a witness if, under the circumstances, it has tendency to rehabilitate the witness's credibility. A prior consistent statement that is admissible to rehabilitate a witness's credibility also is admissible as substantive evidence of the truth of its contents. See the hearsay module, and that's interesting. Okay, so so to rehab with the prior consistent statements, it can be used as substantive evidence. All right, we're done because the next section is hearsay. That's section 7. So we're going to cut this off.